I have found out 16 broad principles, some overlaps. So that will be useful for your lordships to analyze this way or that way. And I'm happy to underline again and again pointillism. So that is the heart of the matter, in the sense that juristically, your lordship has why desirable, what are the reasons, what are the underlying bases, and is it some harebrained idea which has no juristic basis? That's the purpose of these 16 principles. Many of them are culled out from the case law. And I've done the reverse. I put the principle and then put the actual para of the case. Some are not. Some are the way I would like to put it. There are now 5 broad heads. One is the recasting into 2 issues, which your lordships covered with me broadly. According to me, your lordships is not, I'm not saying that the reference is bad per se, don't decide the issue, don't touch it. That's not the point. Your lordship should go into it, but in these 2, which are one, that is the act, does the act inhibit your lordships from having a doctrine at all? And 2, otherwise, is it a desirable judicial policy, desirable interpretation, etc., etc. There's a broad 2 heads. I'll read them in a minute, I'll give you the head. That's one. My second head is, and I think that's a little important. I have tried to do the reverse, analytically cull out from the 10 odd main cases the basis, the justifications, the juristic principles on which the group doctrine can and should be justified. I have found out 16 broad principles, some overlaps. So that will be useful for your lordships to analyze this way or that way. And I'm happy to underline again and again pointillism. So that is the heart of the matter, in the sense that juristically, your lordship has why desirable, what are the reasons, what are the underlying bases, and is it some harebrained idea which has no juristic basis? That's the purpose of these 16 principles. Many of them are culled out from the case law. And I've done the reverse. I put the principle and then put the actual para of the case. Some are not. Some are the way I would like to put it. That's my second head. The third is the extracts from 9-10 judgments, which takes up almost 7-8 pages of my 17-page submissions. Submissions are shorter, but the extracts I put, which adumbrate one or the other of these principles, or don't adumbrate it, but they are my principles, which I am advocating for your lordship's kind consideration and adoption. So this part is the extracts. And lastly, a very brief analysis of the Act to suggest that there is no prohibition explicit, there is no prohibition implied, by any stretch there is no inhibition, forget prohibition. And therefore something which your lordship in the earlier sections has found desirable, good, based on valid principle, absent a implied or an explicit prohibition in the Act, if at all there is a slight encouragement, because that can never be inhibited without some statutory limit or bar. There are 5. The first is only the recasting, 4 broad heads. Now, may I, with that in mind, take your lordships to my submissions. Mostly, my submissions with 2 volumes, which I have, I think, more aptly called CL1 and CL2. Case Law 1 and Case Law 2. More or less covers everything which I have to say, because they cross-reference these 2 volumes. So my WS, my submissions with CL1 and CL2. Give it to them.
Title is List of Authority, Volume 1.
Yes.
Just because you give a title doesn't mean our courtmaster accepts that.
No. Because in fact, I was
He
telling
will have his own.
No. In the other matter, in the other constitution bench, some of this work will also.
It has been emailed to your lordship, personal email also. At 9:30 in the morning, they were received.
No. In fact, I must say something. I must tell you, lordship, I must in fact commend the courtmaster and the staff or something in 30 seconds. Because in the last constitution bench, which was going for a long time and we had more time, even then some things came in the morning. And some of your lordship's email systems were accessible, others were not. So it had to come in the night in most cases, and the ones which were not, we could not get through. I think the lordships in the earlier commission did and the others. Today, given the nature of the suddenness and our logistic preparation, it is given only at 9:30. But I'm told that they have been loaded onto your lordships, which is very, very creditable, because there was no way we could do it before that. We made separate hard sets, just in case your lordship don't have it.
I do not to my.
Right. Now, if your lordship sees the recast at B.1 of my note,
Yes.
whether the acceptance, adumbration of the group companies doctrine by the Honorable Supreme Court in several earlier judgments is not permissible within the four corners of the 96 Act, therefore contrary to statute. This would more or less cover the legal issue according to me, without being specific about sections, but 96 Act. Divorce A above, which possibly may not arise, but I'm putting it against myself since the lordship in the Constitution bench dealing with the subject, your lordship might as well give the larger picture also. That's the only reason I put it. Whether the Honorable Supreme Court should at all have accepted adumbrated the above doctrine as a matter of desirable judicial interpretation and judicial policy. Well, para B.2 tells your lordships that Honorable Chief Justice Ramanna's formulation would be under this. It would fall within these two issues. Well, as Justice Suryakant, whereas 1042, 3 and 4 are really reasons of his judgment, which is my para B.4. And the first one covers and is subsumed under my two issues. I'm just reassuring my lord that nothing is really left out. Now your lordship should come. I'll read the case law later, but just come to the conceptual part. This is the most analytical part. C 1 to 16. 16 principles which I have called out. And lordship will just go slowly here, and then we'll read some of the case law later on. May I read this? Summary of principles culled out from existing Indian and foreign jurisprudence, establishing the clear desirability of recognizing and applying the doctrine of group companies and common economic entity in arbitration law. This is my issue B, not my issue A, not the statute. This is issue B. The doctrine constitutes a true and genuine effectuation of the real intent, italics, of parties. Now, actually, these paras use this most liberally of these judgments. Actual paras are given. And there is no reason why the true intent of parties to subject not merely signatories but also related and group entities should not be effectuated. Well, as one batch of cases puts it rightly on the salubrious principle of real intent, true intent. And that is the basic principle. I've given 5 cases, there are more ones. Second, the doctrine evolved in the context of related entities playing a predominant role both at the negotiation stage, which is at the inception of this, as also in the course of performance of the contract, even though they were not signatories. And I'm asking myself at each stage, what is wrong with this reasoning? What is unjust about this approach? My respectful submission is nothing. It is desirable because it is just, fair, and honest, otherwise logical and correct. My third principle. Well, there is an error. The word not has to be deleted. I'm sorry. Last line of C.2.
Yes.
Even though they were non-signatories, not non-signatory. I hope I'm clear. The not will go on. We'll also cut it out. Third principle. Absent such a group companies doctrine, it would allow evasion and avoidance of legitimate collective responsibility arising from the contract and permit injustice. You also see the synergical cumulative impact of all the 16 at the moment reading the numbers. Indeed, to extend the previous point, this is a separate point, it would also facilitate evasion of law through a hyper-technical approach. 5. The group companies doctrine is a reasonable and natural extension of the piercing of the veil doctrine, and some or all of the already established legal tests in corporate law regarding piercing of the veil would, depending on individual facts of individual cases, also arise in favor of the application of the group doctrine. Now, there is an overlap here. For example, take alter ego. Alter ego has been a lordship test to pierce the veil. It would apply here also. Some will not identical, but this is a further natural extension to arbitration law of what is already an established doctrine in corporate law. 6. Juristically, the group companies doctrine is also fully justifiable when the requisite and sufficient degree of common ownership and control exists, and there is no reason why such persons, entities should be able to avoid legitimate responsibility on the technical plea of non-signature. Collective. A seventh principle is one where your lordship finds gross injustice is caused. Your lordship must apply. Sorry, gross injustice. That's the seventh. Then another account of implied consent in 8. There is no reason, the doctrine can also be justified on the separate juristic basis of implied consent, a well-known concept in the law of contract and arbitration. 9. There is no reason why the group doctrine should not apply if there is a direct relationship between the parties, which is a signatory to the arbitration agreement. This I am putting from a judgment to us. Direct commonality of the subject matter, the composite nature of the transaction between the parties, full stop. A composite transaction refers to a transaction which is interlinked in nature. Then was the next principle, and this is jurisprudence. Gary Bond, an outstanding jurisprudence from the continent, German, who is settled in the common law system, has written some very good books. The principle is equally justifiable on both purely consensual theories, he says, agency, assumption, assignment, and non-consensual theories, estoppel, alter ego. And this, your lordship, has approved this para Charan from Gary Bond. I believe my lordship, Charan. It is a vitally useful doctrine to prevent, this is very important, fragmentation of disputes. Kindly note this. And therefore, it is highly desirable for a legal and judicial policy. Then, 12. It is of particular relevance contextually in India, a country whose business and commercial structure is more heavily reliant upon traditional forms of family-run businesses, where technical distinctions between signatories and non-signatories would cause grave injustice. Justice Suryakant had a whole paragraph in Cox and Kings read to your lordships yesterday on the family business nature in India. Then 13. The doctrine of purposive or teleological interpretation adopted by courts in diverse situations necessitates the application of the group company doctrine to deal with the core issue at hand and prevent injustice arising from technical avoidance tactics based on formal signature or absence thereof. 14. The alter ego doctrine, already known to corporate law, proceeds on the assumption that 2 or 3 entities formally, but this formally is wrongly typed, it is ALLY. Formally. That is ostensibly one. Formally distinct are nothing but de facto alter egos of each other and must necessarily be seen holistically in the process of dispensation of justice. Now, when I come to something which will be relevant in the law also, but actually on the desirability, I've dealt with it here. 15 and 16 are related laws. So we just read 15 and 16. By the 2015 October Amendment to Section 8, by Act 3 of 16, inserting the words any person claiming through or under him, In turn, based upon the reasoning of the 2246th Law Commission, my lord saw that yesterday in the judgments I have cited the para, the legislative intent to recognize and codify the pre-existing reality of non-signatories, effectively acting through or under signatories, is statutorily recognized so as to do complete justice. Now I come to Willis, what I call a red herring of 21H, which also engaged your lordships yesterday. The absence of a corresponding amendment to 21H at the same time as Section 8 was amended would be irrelevant to the interpretation of the latter. Firstly, the amendment to Section 8 has to be construed on its own terms, and both the Law Commission report and the words added to Section 8 in 2015 are crystal clear. Secondly, the effect of those words and the intention reflected in the Law Commission report as adopted by Parliament cannot be nullified or diluted by recourse to what might or might not have been done in another provision, namely verse 2H. Thirdly, unless the three-judge bench in Chloro is held by the Honourable Constitutional Bench to be erroneous or unsustainable, it is clear, this is important, it is clear that full mind was consciously applied by the Chloro bench to this issue, while contrasting the language of 45 and 8. After contrasting, thereafter the Chloro bench proceeded to read the group doctrine into 45, principally on the basis of the difference in language between 8 and 45. That's paras 94 to 96 of Chloro. Fourthly, if that be so, the subsequent insertion of the same words in 8 by the 15th Amendment must necessarily have the same effect of introducing the group doctrine into 8. Because far from the legislature making any attempt to dilute or overturn Chloro, they were in fact effectuating and endorsing the intent of Chloro Way 45 to another section of the same act, namely 8. Lastly, verse fifthly, the latter clear intent of both Chloro and of the legislature in enacting 2015 and indeed of the Law Commission cannot in any manner be diluted or nullified by reference to what could be done or might have been done but was not done in respect of 2H. Such an approach to interpretation to whittle down the true intent of Chloro or the Law Commission and indeed of the amendments would be unjust, unsustainable, and unfair. Whereas these are my 16 principles conceptually, analytically, which is the totality of what I have been able to call out. They show us A, this is a doctrine based on valid juristic principles, diverse. B, none of these principles are undesirable or need jettisoning by your lordships. I mean, there could be a principle which is most objectionable. None of these are like that.